Welcome to A Taste of Justice. I'm Professor Angela May Kupenda, and this series is for all of us. Look, the Constitution says we the people, in order to establish justice, learning and enlightenment will take us on that path to justice, or at least to a bigger taste of justice. This series is also for my students. I'm teaching remotely to give them a little something extra to help them in their review of the lengthy cases we covered in class. So I'm going to tell you just for informational purposes. All explanations here are my own, but I'm a professor of law at Mississippi College School of Law, and I've been teaching in business schools and in law schools for about 30 years now. First Amendment is one of my favorite classes to teach, and it is highly relevant today. Don't you agree? So let's get right to it. So we have these general rules and general principles in First Amendment. We know now that our First Amendment rights, like other constitutional rights, are not absolute. A key consideration for speech is whether it falls in an unprotected category. You see, generally, the government cannot regulate the content of your pure speech unless it satisfies a very high level of review. However, the court has said there are some unprotected categories of speech. If your speech is in that category, government may regulate it if government chooses with a very low level of review called rational basis. All government needs is a legitimate governmental interest, and the restriction on your speech must be rationally related to that interest. So in analyzing these problems and also in analyzing current events, perhaps the first question is, was the speech in an unprotected category? And was government regulating the content of that speech? Now, in the prior clip, now I admit it's a long one, the prior clip is a long one. And when I listened to it, I'm like, wow, I sounded maybe a little sleepy. You know, it was kind of early when I recorded it. So I'm trying to pep things up a bit. The prior clip went through all of those historical cases. Those historical cases are quite important. The principles really don't just go away. They can come back in various ways. And some of the things the court pointed out, you look at the times, you look at the factual circumstances, you look at the governmental interests, all of those things still continue to be relevant today. Now, we're not going to go back through the historical cases. Fortunately, they're there in that prior video. What we're going to do now is look at what is called the modern day test. Now, remember, we're looking at whether speech is in an unprotected category. The specific category we are considering is speech that advocates illegal action. So how do we know if a given speech advocates illegal action to the degree that it is placed in an unprotected category and where government can regulate it more freely, generally? So we're going to look today at the modern day test, the test that is frequently cited as the test for speech that advocates illegal action. And it comes out of a case called Brandenburg. The Brandenburg test, Brandenburg versus Ohio, a 1969 case. Now, what happened in this case? Well, there was a member of the KKK, and I'm sure you've all heard of the KKK. If not, you can Google it. There was a member of the KKK who did an interview on television. And in his interview, he was armed with guns, with a Bible, and a red hood that he wore. On one film, there were 12 hooded individuals present with the speaker, and the speaker made some derogatory comments about Black people and others. For example, the speaker said things like this: if the government continues to suppress the white Caucasian race, it's possible that there might have to be some revenge taken. Let me repeat that again. This is what the speaker said, and I'm reading from the case. If the government continues to suppress the white Caucasian race, it's possible that there might have to be some revenge taken. The speaker, who was wearing the hood, he said they were going to march in Congress, in Florida, and guess where else they were heading? And sending one group on to Mississippi. There were some other comments too. He said things like Negroes, but he didn't say the word in that way. You know what I mean? He said the N words should be sent back to Africa and Jews should be sent to Israel. So this speaker was charged and convicted for violating the Ohio law. He appealed that conviction. His argument was that his speech was protected speech, that it was not unprotected speech. Now, how do you think the court ruled in that case? If you look back at the Shank cases, the Debs case, Abrams, and all of those cases from before, including the case about Charlotte Whitney, you likely said, oh, he's staying in jail for that. But that's not what the court held. The court ruled in favor of the KKK speaker. In this case, the court said that Brandenburg's speech was protected speech, was not in an unprotected category. So in this case, the court articulated what we call the modern day test. The test the court used was more similar to what Judge Hand had advocated for, and also what Justice Holmes and Justice Brandeis had said in some of the later cases. Now, this is the test, the modern day test to determine if speech advocates illegal action. The court said that the speech must be advocacy, not teaching, but to advocate, directed to inciting or producing imminent lawless action, and is likely to incite or produce such action. So that test is loaded. I've typed the text in the textual box below this video so you can look at the language of that test. Speech fits in the unprotected category of speech that advocates illegal action under the Brandenburg test if, according to the court, it is advocacy. So you have to be advocating for a result, not just teaching about something. If it's advocacy, directed to inciting or producing imminent lawless action, and is likely to incite or produce such action. So the speaker was released with the conviction being reversed. As the court said, the speech was not in the unprotected category. Therefore, in order for government to punish him for this speech, government would have had to meet a very high level test and not the low level rational basis. Now, there was no dissent at all. The justices all agreed that this speaker had speech that was not in the unprotected category. One justice, well, several, wrote what's called a concurrence. A concurrence means they want to make an extra point. Justice Douglas said that he pointed out that even if the older cases were useful during times of war, those older historical cases were not useful, those rules, during days of peace. Now, often when we covered this case in class, I have students who agree with it, and I have students who vehemently disagree. Some students said, why did they create a test that protects speech more when it dealt with issues of race and potentially racial harm? You know, Justice Douglas said that these were days of peace, so you allow more speech. But some of my students in the past said, we were not in a time of peace. 1969, especially in Mississippi, the state was not following Brown versus Board of Education fully yet. Many individuals still were struggling to have the right to vote, to be allowed to vote without suffering potential harm or even the loss of their employment. And even though the speech was not about the Vietnam War or conflict with the mandatory draft was still going on during this time. Regardless, the court articulated this modern day test. So let's go back. The general rules, speech rights are not absolute. Another general rule, the First Amendment does not protect pure conduct. It protects pure speech. Another rule, government may not regulate the content of pure speech unless government satisfies a very high standard, or unless the speech falls in an unprotected category, of which there are several. One category of unprotected speech is speech that advocates illegal action. We have a whole series of historical cases from the early morning clip I recorded. Those cases may be still kind of out there. You have to still kind of keep them in mind. But the modern day test, the widely accepted modern day test, is the test of Brandenburg versus Ohio. And in this case, the court held that speech does not fall into the unprotected category unless you're advocating for something. And then that advocacy is directed to inciting or producing imminent, that means it's going to happen soon, imminent lawless action, and the last part, and the speech is likely to incite or produce such action. So the court held in the Brandenburg case that the speech by the member of the KKK did not rise to that level. Now, if you're thinking back to the earlier clip, right now your mind may be going back to the marketplace of ideas theory, where Justice Holmes talked about letting the speech into the marketplace and then perhaps the truth will prevail. You may be thinking about that and whether the holding in Brandenburg is more consistent with the marketplace of ideas theory than the holding in some of the historical cases. As I'm recording this, we're about to celebrate the birthday of Reverend Dr. Martin Luther King Jr. And I know you'll probably hear a lot of his speeches on the radio and what have you, but there are some of his speeches that you probably won't hear as often. You have to remember with Dr. King and during the Civil Rights Movement, and one of my uncles was a leader of the NAACP in Port Gibson, Mississippi, you'll see that the nonviolent protests, while we celebrate Dr. King today all over the nation, during that time, his speech advocating for racial and class and other types of equality, his speeches were not as well accepted. And of course, we know he was assassinated. Now, I was thinking about Dr. King and one of his books. If you're looking for a good book to read, let me just encourage you to consider this one. It's called Where Do We Go From Here? Chaos or Community. And it's just a very insightful work if you're looking for something additional to read on the King holiday. So again, remember, learning is a key to enlightenment, and enlightenment is a key to our achieving justice, or at least a taste of it. I've gone through the historical cases with you on speech that advocates illegal action. We just talked about the modern day test of Brandenburg, and I'll leave it to you as to whether you agree or disagree with that holding. Regardless, that is the modern day test. In my next clip, I'm going to tell you about a post 9/11 case. The post 9/11 case makes us go, is Brandenburg still the test, or has 9/11 and the country's need to deal with terrorism led to some rules that may be less restrictive of speech, or is Brandenburg still the test? Look, subscribe and sign up for notifications. You don't want to miss a thing. Thank you.